Hello, everybody, and welcome to another Cafecito. I am so excited to be here with all of you today. We're starting the summer, so I hope you're all like getting ready to at least take a little time off. I know many of us are juggling multiple things always, but it's good to take a pause and to rest. So hopefully you're all finding that time at some point this summer. But today I am very excited to have a guest here that's going to talk to us about wills and trusts and all estate planning and all of these things that all of us should do and should know. And I know that I don't know a lot of it, but it is something critically important because it is part of making sure that all our lives work actually doesn't get lost and gets passed on. And so it's very important. It's a very important conversation. I'm very excited to have Claudia Soto from Soto Law here with us today. So Claudia, thank you so much for making the time to join us.
Oh, absolutely, Liana. Thank you so much for having me. I'm really excited about this, being able to talk about this topic. I know we kind of touched on it when we were having a discussion, you and I, and just all the things that we don't hear about, right? That we kind of we think we know, and then realize, wait a minute, I don't have any of that stuff in order. And I think that's where this kind of grew out of, right? It's a very common thread for us to know a little enough about it that it exists, but not enough to know where we need to start, what we need to do.
Absolutely. And especially if, like in my case, and I know that many of our audience is in that same case, we come from other countries where maybe we do have something in place in our countries of origin, but then you come here and it's a completely different thing. And I think I'm still 15 years later trying to figure that out. In my country, no brainer, but
Yeah.
here I'm still trying to figure it out. And the first thing when I got here, somebody said in a meeting, or I can't even remember, but I remember hearing estate planning.
Hmm.
And it was like, I have no idea what that means, but probably it's not for me because it felt like something that I heard in the movies for very, very rich people.
That's
So I
right.
felt like it wasn't for me. And up until recently, I'm starting to understand that, yes, it's something that we have to do and that it's very important to do.
Right.
So let's start there. Like, what does it mean? What does it look like? Like,
Yeah.
take us take us
Yeah.
along the journey.
Absolutely. So yeah, I think you kind of hit one of the biggest notions is that the word or the phrase estate planning seems a little very what do you get in Spanish? You say the tacon alto, right? It's very high end, and it's you think this is only applicable to folks who are have a really large net worth, multi-million dollar net worth, and it's not the case at all. It really is just a planning tool, and everyone needs to plan because of this. I hate to go to the saying that we've all heard, which is the only thing sure in life is that we're all going to pass away. It's not a fun thing to think about, but it is clear that that is where that's the end of the road for all of us. And being able to plan how, what, who is going to handle all of the affairs, and in hopefully helping walk through that during your lifetime is what estate planning is, right? You could be planning for a multi-million dollar estate, which is fine. There's different planning tools and needs there. But then you could also just be planning for maybe disability, or planning for one property that you bought. This is the house that you bought, you built. Maybe this house was built. You don't want it to ever be sold. You just want your family for generations and generations to live on this property. Well, that's also part of estate planning. So there's a tons of different reasons and goals that people have in their estate plans. It may be tax savings. It may be liability protection. It may just be leaving things organized for your beneficiaries and your loved ones so they don't have to figure it out. And so yeah, it applies to everyone in many different ways because there's so many different tools that we can use depending on the circumstances, right? We don't all need irrevocable trust, which I'll kind of touch on in a little bit. But there are basic things that we probably all should have, like a power of attorney. That's a big one that is, it's for everyone. So that's like that. That'll kind of get us started on the subject matter of estate planning, right? And I think one of the things you and I had talked about is what's the big deal with a trust, right? And fideicomiso, they call it, and it has so many different names. They call it a trust, a living trust, a revocable trust, all sorts of things. And so I think one of the things that I wanted to share here, mostly because this is one of the topics that I talk about the most, is what is the difference between a will and a trust? Do you need both? Do they have to exist together? And I think I try really hard to, when I talk about these topics, to talk in very just everyday vocabulary, because that's the only way this stuff is going to stick, so that you can remember it later. There's no point in me telling you all the legalese and telling you all the words that are used in the drafting of documents, because you won't remember it when we get off this podcast. It's just not something that'll stick in your mind. So here's the best way that I explain this. So a will is el testamento, right? A will is your wishes. That is a document that exists for you to be able to put in writing how the distribution of your assets will be handled. What is it that you own, and who do you want those assets to go to? Those assets continue to be yours through your lifetime. So the only time a will becomes relevant for it to be used and to be interpreted would be upon your passing, because while you're living, the will does nothing, right? You can change it, you can get rid of it, you can revoke it, you can do anything, because it only comes into play once you've passed away. And so that's what the will is. The will does not give the ability for you to do anything post that moment of death, and the process with the court system to distribute the assets. Now, I have to give a disclaimer. I'm a North Carolina licensed attorney, North Carolina only, and every state has different laws and procedures for estate planning. For what we call probate, it may be called different. The process may be different in other states, and so where I'm coming from as far as just generic information. I'm trying to stay high level so that it doesn't conflict with anybody's state procedures and rules, so that I don't confuse anyone. Clearly, I'm not giving legal advice, so that's that part. I think we could check that box. This is not legal advice, but I do want to give you guys kind of a general idea of what these tools are, because they are applicably, in concept, they are the same anywhere, right? In concept, you've got your will. Your will is going to determine where your assets are going. And if you don't have one, then the state law will take role in deciding how those assets are distributed. So, usually if you have, at least in North Carolina, if you have a traditional family, husband and wife, 2 children, and one parent passes, then the spouse and children are, by statute in North Carolina, the heirs of that person who passed away. If you wanted to distribute your assets in any other way than what the statute says, then you have to put that in a will, so that it goes through a different distribution. So I know that in some Latin American countries, you can't disinherit a child, right? Or a spouse. In North Carolina, to a certain extent, you can't completely disinherit a spouse, but the concept of saying, well, I want all my assets to go to my one child, not to the 3. You can do that, right? Now, the people want to do that, that's a different question, but can you? Yes, you can in North Carolina. And so if you want your distribution to be different than what the state statute has as the distribution of assets and who the heirs are, then a will would be the instrument that you want to look to. Now, the difference between the will and the trust is that once you go from a will to a trust, you're going now to creating an instrument. The trust is creating an instrument that serves almost as a container. This is how I explain it when I'm in person. I'll grab a container, like where you put, if you're in a conference table, you put your pens in a container, right? Well, that container is the trust, and the pens in that container are the assets. So what we do when we create a trust is we're creating this container with instructions. And the instructions is your trust document saying, for all the pens that are going to be in this container, all your assets that are going to be in the trust, this is what I want the distribution to look like. Now, here's where the big difference comes in. So far, that sounds the same, right? The will and the trust sound the same. The difference is that in the will, you're not putting pens into a container. You're not putting your assets into a trust because you continue to own your assets when you have a will. Okay. When you have a trust, you are now moving the ownership of the asset to be owned by an entity or a trust, which will become a independent trust once you pass away, which means that will be the owner of the asset immediately upon your death. And during your lifetime, you own it, but in the capacity of a trustee of your trust. It's kind of like an open container during your lifetime. The minute you pass away, the lid goes on the container. Now that container is kind of solidified and becomes independent. It has its own identity, where now the instructions that are in that trust document is how that asset's going to be distributed. Now, that means that title's changing. So for items or for assets such as real estate, that's the easy one to use as an example, is you would be transferring title to the real estate from your individual name into the name of the trust. And technically speaking, not the name of the trust, but the trustee. So like, let's say, for example, Claudia Soto, trustee of the Claudia Soto Revocable Living Trust. That's who would own my real property versus just Claudia Soto. So that upon my passing, when the lid closes on that revocable trust, then my instructions that I left it for my container, for my trust, will be you have to abide by that distribution, and there's no changing it. During my lifetime, because it's an open container, I can change the distribution anytime I want. I can put more assets in, I can take the assets out. I continue to control what's in the trust if it's a revocable trust. Is that kind of showing some of that differentiation between, okay, I own these items, these assets, this is how I want them distributed, or through the trust, I owned these assets, but now my trust owns them and I own the trust. So you own it through ownership of a trust versus through yourself individually. And the reason you want to do that is because when you own an asset individually, the court system has to supervise the distribution because the person that owned it doesn't exist anymore. In a trust situation, the person that owns the asset is the trust, not the person, not the individual. And so even though the owner of the trust passed away, there is a successor trustee that takes over, just, in similar fashion as a company, right? Or a corporation. You've got the next line of ownership or management that's going to take over the business. It doesn't have to go to the court, right, to be managed and operated. You've got the next line of folks who might be taking over and following instructions. Similar format, the trust does the same thing. So the court doesn't have to oversee this process. It's completely outside of the court's purview, private, and you don't have to probate. That's what it's called in North Carolina. You don't have to go to the court, open an estate, do an inventory of what the assets are, and do all these procedural steps in order to sell or manage or move your assets around, or for your beneficiaries to do so.
Yep. And is the estate, thank you for sharing it in this like plain language. I'm like,
Yeah.
oh, I think I get it. When you talk about the estate and especially the trust and especially the trustee, is that trust and trustee, could it be like an individual, or does it have to be
Yeah.
like a company, an organization,
No. So
fund,
it could be anybody.
whatever?
It could be an organization, a company, a bank, corporate trustees. but it could not be, right? You can, that's the beauty with the trust document, is a tool, is that you have a ton of control. You can do whatever you want, honestly. Well, not whatever, but mostly whatever you want, to control your assets beyond your passing. And you can name, so like, I'll give you an example from my trust. It's the Claudia Soto and my husband trust, right? And the original, or the granting trustees, are my husband and I. So we are the ones that created the trust. We are the trustees. Upon both of our passings, then we have a list of successor trustees, which would be, let's say it's my brother or my mom. If my mom's living, then my mother. If my mother's not living, then my brother. Or you could, which I don't recommend in most scenarios, you could have co-trustees. If I had two siblings, I could say my brother and my sister together are the co-trustees of my trust, and they have to make decisions together. It's not a great setup, honestly, but that's an option you can do. But more commonly, it's a successor, alternate. So if the first person that you chose is not available or able, then the next person comes into play and will be the successor trustee to follow the instructions for the benefit of the beneficiaries. And the trustee could be a beneficiary, right? So my brother and my mother could be part of the beneficiaries of my trust, but they could also be the trustee, the one that manages, kind of like the manager of
Yeah,
this entity that's now been solidified and fully independent now.
yeah. And what happens when like that trustee like passes away? Like can they establish another trust that sort of takes care of the original trust, so to
Yeah.
speak?
Yeah, so the trustee, if all they're doing, if they, let's say the trustee passes away, whether they were, whether they passed away before the person that created the trust. So let's say my mother or my brother, who are my trustees, passed away before I passed away, then there has to be, you can list as many people as you want, right? You could have a list of 10, successor, 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 successor. Most people don't have that many folks to keep going down the line. So what happens is, in any event where there is no instruction or the instruction fails, then it reverts back to the state statute, right? The way the state statute would handle it, had there not been a trust at all, is the way the distribution will fall. But most of the time, you've got enough people in the lineup there that you go to the next person. If the one, and if somebody already was, handling the trust, and then they pass away, same thing. The next person that is listed as a successor from that list will take over as the trustee, and they just keep managing the trust. Now, a lot of trusts are meant to be fully, dispersed at within a good short period of time of the passing of the creator of the trust. Some of them are meant for longer term trust, for generational wealth goals, legacy goals, control goals for the children. Maybe you have children whom you don't trust have the financial savvy to take on a large inheritance. Well, you can trigger a lot of things. You can condition the distribution on a lot of things. You can, college, marriage, financial advising, different things that would be required in order for them to be entitled to the asset or the distribution, which is not something you can do with a will. Oh, court's not going to manage anything for you. They're just going to say, as a person of age, 18 years old, then here you go. Super responsible, not
Yeah,
responsible at all. You're entitled to it, and here it is. With a trust, you have the ability to condition the distribution
yeah.
over a
And
long period of time if you want.
I know a lot of our members are business owners, maybe also people watching.
Yeah.
Like, how does then ownership of a business work in terms of again,
So
all of these planning?
yeah, so that is one that I feel like a lot of people forget. Not, they don't forget that they own the business. They forget that their business interest is an asset. The business itself, yes, but the interest in the business is the asset, right? So if you have a business, one of the one of the ways that you can incorporate it into your trust is if your trust owns the interest in your business instead of you as an individual owning the interest in your business. Therefore, upon your passing, the interest in your business, you have instructions of distribution in your trust, and that also coincides with your operating document or bylaws, or your your operating documents for your company also have to have language that allows the trust to be the owner of the interest, that speaks to the passing of the maybe member or members of the business. When you have multiple members, you got to think about buy sell agreements, because if you have a company that you own with someone else, or you have multiple members, one member might not want to own the company with your heirs. And that's usually the case, right? You don't go into business with the family of your partner, you go into business with your partner. And you want to have something in place, such as a buy sell agreement, that dictates what happens upon the passing of one of the two members or owners, partners, who is entitled to come in and take that interest, who's going to be required to sell that interest, and under what terms does that interest get sold to the surviving partner, right? All of those things you have to kind of talk through and do early when things are good, not when someone has passed or someone's trying to leave the business. I've heard it called the prenuptial of business.
Of
Uh,
business, yeah.
yeah, correct. You kind of, when times are good, you want to talk about what happens when the divorce happens or when someone passes.
Absolutely, absolutely.
Mhm.
So I know we're getting to time here, and so many other questions that I have are very important. But I think the most important one is, and it happened to me, like who do we reach out to when who do we reach out to when we want to like figure this out, or at least start the planning, right? Is
Yeah,
it like, is it a lawyer? Is it a somebody in finance? Is it like,
yeah.
who do we how do we start?
Right. So I think one of the starting points could be an attorney, with just understanding what does your estate look like. There's a ton of plans that you can come up with based on your circumstances, because there's different tools that we use depending on your net worth. There's certain thresholds of net worth that trigger a different conversation, because now we're maybe not just looking at estate planning for purposes of how do I leave things and control the distribution upon my death, but how do I avoid maybe some taxes, estate tax, and how do I protect some of my assets if I'm a high net worth or possibly risk averse type of profession. What do I do to try to help protect some of our assets through estate planning tools like irrevocable trust? Irrevocable trusts are a little different than revocable ones, because they are closed lid trust. The revocable is that open lid trust that you can put in, take out, change, maneuver. Closed lid trust, you can't. You put it in, it's closed. It's like a capsule, right? Now you got to know what your structures were, and be comfortable with the fact that you don't need to go back and reach for those assets during your lifetime. Um, for different reasons. There's a lot of different reasons, which we have no time to kind of go into. But I think the first step is maybe reaching out to an attorney, and I definitely think that in estate planning, to get a full picture, and especially if you own a business, it's a combination of the attorney maybe first, and then financial planner, absolutely, and a CPA. So those three professions are key to fully understand and have a full functioning plan, right? Because you could talk to someone like me, an attorney that tells you, hey, here's the things you do for liability protection and for estate planning, but then I can't advise you about the tax planning. And then I can't advise you about some of your retirement or some of your investments, and because there's different things with investments that have their own beneficiary designations that don't necessarily have to be accounted for in the estate planning part. So I would say attorney, financial advisor, and CPA. And hopefully your attorney's got the relationships with these other two professions that they can connect you if you don't already have connections there, so that you get the full circle of information.
Amazing. Thank you so much for this, because I think it's critically important. To your point, it's something that we don't think about because we're not thinking about passing away tomorrow, right?
Mhm.
But it's critically important because you never know what's happening. And also, and I know we don't have time for this, so we're going to have to schedule something else.
Yeah,
But also, I think many of us are heading into that moment where we are also caregivers to our parents, right? More and more. And then there's other issues there that I'm seeing happening that I think we need to think
yeah.
about.
And I'll do a quick
And then
plug,
we need to
Leanna.
help our parents think about as well.
Yeah, I'll do a quick plug because this is one thing I told you. This one's good for
Yeah.
everyone. Is the power of attorneys. It's part of the estate planning tools. Powers of attorneys for the for elderly parents. Honestly, for children that are turning 18 and going to college, good idea too, right? You just never know if there's a situation in which you're going to need to be able to speak on behalf of your adult child, which we think they're children forever and we can speak for them. After they're 18, we cannot. Once they've turned 18, they're adults, and so in order to speak and act on their behalf, you need a power of attorney. So that is a very recommended route with your children turning 18, going to college. A power of attorney is a great tool to have.
Wonderful. Awesome. Claudia, where can people reach out to you?
Yeah. Well, so like I said earlier, I mean, yeah, I'm happy to talk about this subject at any time and in a general sense. But my firm, I own a firm. It's Soto Law, and we are in North Carolina and Charlotte. We have three offices in Charlotte and one in Raleigh. And my number for the office is, I'm gonna just give you the number here. So 704-270-6027. And I'm happy to have conversations about this with anyone, but I will say that if you're looking to do any of these documents or prepare documents, it would be based on the state that you reside in, not necessarily where the property is, but where you reside. And so that's a little tidbit, but I'm happy to speak to anybody about it. I love being able to talk about this topic and just concepts. I think those are pretty nation wide, and I'd love to have the conversation if someone's interested.
Wonderful. Thank you so much, Claudia. And we'll
Thank you.
definitely schedule another time in the future because so many other great information that we all need to know. So we're fully prepared, right?
Yeah,
We're building wealth. We're building this, this great nation, and now we just need to protect it for
yeah,
everybody else and our future generations. So thank you so much for
absolutely.
everything.
Thank you so much, Elena. Thanks for having me on the podcast. This was great.
Awesome. Thank you, everybody, and hope you have a wonderful rest of the day wherever in the world you are, and see you next week. Have a good one.
Bye.
Bye.